The two Republican senators who were holding out against Blanche's confirmation have now agreed to a deal with the Justice Department. Here are the top 4 reasons why this deal is no deal at all, and it certainly doesn't justify a vote to confirm the likes of Todd Blanche. Number 1, in the 1-paragraph statement that Todd Blanche signs, doing away with the order, he doesn't do away with the settlement agreement, the whole foundation for the order. That is, they've already signed, the parties, an agreement to set up a weaponization fund. He just got rid of the order that would do so, which means that the president, who's made it clear he still wants this fund to go forward.
So I view that fund as a positive, and a lot of Republicans do too.
Can resurrect it in the future by a new order, either from Todd Blanche or a new Attorney General. So remember that Senator Cornyn raised serious questions about the agreement during Blanche's confirmation hearing.
On page 4, this settlement agreement may be modified only upon the written agreement of the parties. Has there been a written agreement of the parties to modify the settlement fund?
No, the settlement fund's just not moving forward. So I suppose if President Trump's counsel sought to enforce it, they potentially could.
Thom Tillis also spoke critically of this deal and the need for clarification. Despite comments as late as yesterday that the fund is dead, President Trump clearly intends to resurrect the payout pot for punks, either by inappropriately establishing another bogus fund or pushing Congress to vote for a bill that the majority of Republicans in the Senate would be against. Sadly, that payout pot for punks still exists because they can use the judgment fund or they can resurrect the weaponization slush fund with a new order by Todd Blanche or a new Attorney General.
He should listen to Blanche and others who think if it's dead, it should be rendered completely dead.
So number 1, this fund is not gone for good. The president has made it clear he wants these payouts to continue. Number 2, the administration is already paying off these enablers and cronies just using a different slush fund. It's called the Federal Tort Claims Act, and people are already making claims, and hundreds more, including those active on January 6th and attacking cops, have made it clear they intend to apply for government funding anyway.
Georgia liars, cheats and crooks, change the rules and you burn the books, and so I don't believe a single word you say. You're all liars, fakes and cons, want you out and we want you gone, so don't believe this time you'll get away. You want us tricked, you want us numb, you want us scared and you want us stung, you want us shot and you want us bought in every way. You want our minds, you want our time, you want us framed up in your crime. I hope you know that it's time to go and we're taking names. 'Cause you don't get to tell us what to think and what to do. No, you don't get to tell us what is true. You're just liars, cheats and crooks, change the rules and you burn the books, and so we don't believe a single word you say. You're all liars, fakes and cons, want you out and we want you gone, so don't believe this time you'll get away.
There's a judgment fund at DOJ that can be used for this purpose, tragically abused for this purpose, and they've already started doing it. You might remember this guy. That's Michael Flynn. He pled guilty twice during the first Trump administration to lying to the FBI about his illicit contacts with the Russians when the Russians were trying to influence our elections. The prior Trump administration, the prior Trump DOJ, and Trump 1 dismissed the case after Flynn, even after he pled guilty repeatedly. Mike Flynn got $1.25 million out of this judgment fund already just this year, not even drawing on the slush fund set up by this settlement. If these two Republican senators truly wanted to kill the president's ability to pay off these January 6th insurrectionists and cop beaters, they need to put that in statute, something we ought to take up in Congress. They haven't, Congress hasn't, which means those payouts are going to continue, notwithstanding this 1-paragraph statement from Todd Blanche. Number 3 of the top points you need to know about this non-deal is that Blanche's statement about the tax deal that Trump got. This immunity provision isn't worth the paper it's written on. He didn't even sign it. All this new provision says is the following. A transcript of the acting attorney general's testimony is attached. He incorporates that testimony by reference and restates that it is DOJ's interpretation that the order only has any effect, including on any release of claims, on the named parties in the lawsuit referenced in the order. So what does that mean? It means that this unsigned statement is merely expressing an interpretation of the department of what's in the settlement agreement. So the settlement agreement, which is much broader and provides this, that it protects any of the plaintiffs or related or affiliated individuals, including without limitation, family or others filing jointly, or parties including trusts, parent, sister, related companies, affiliates, and subsidiaries by reason of, respect to, in connection with, or which arise out of, one, any matters that could have been raised in the case or the pending agency claims or were raised, lawfare or weaponization, any matters currently pending or that could be pending. That's the language of the actual settlement agreement. There's no limitation on that. And Blanche saying that his interpretation or the department's interpretation is different doesn't mean the actual parties to the agreement, including Donald Trump, his family, his affiliates, his subsidiaries, can't contest that unsigned statement and its so-called interpretation. That interpretation, again, not worth the paper it's written on. But finally, the fourth thing you need to know about why this deal is really no deal at all, not for taxpayers, not for the public, not for anyone except for Donald Trump, is that it still gives the president probably $100 million in value, even if you accept the representations of Todd Blanche, which we shouldn't. It still covers Trump, it covers his kids, and it covers the Trump organization. Just those entities alone, just the president alone, declared more than $2.3 billion in income last year while president, which means any tax liability for any of those billions, assuming they filed their tax returns before this agreement was entered into, cannot be audited, examined, questioned. Whatever tax fraud may have been perpetrated, whatever underpayment of taxes may have been conducted, none of that is actionable by the IRS, even under the most favorable interpretation given this agreement by these two Republican senators and by Todd Blanche. Those are the four reasons this is no deal for the American people, but a great deal and a face-saving deal for Todd Blanche and the president. He should still be rejected for confirmation.
Thank you, Senator Booker, for holding this hearing. Thank you all for testifying. And Mr. Carbone, I couldn't agree more. It's a staggering conflict of interest, self-dealing. I wrote down the three words that Blanche used to describe that IRS sham of a settlement. I think he said regular, typical, and I can't remember the third, but they were anything but accurate descriptors of that unique agreement, which, as the judge in Florida pointed out, has relief for people who are not even parties to the litigation, to the degree there was any litigation, with remedies that have nothing to do with the alleged offense, and uses such broad terms as to be really totally in the eye of the beholder. And I think Senator Cornyn was right. It was also quite striking that Blanche attributed to himself the power to speak for people on both sides of that agreement by saying that it was dead. How could he speak for the other side of that agreement? Well, because he was on both sides of the deal. But I want to start by asking Mr. Carr a question. I asked Mr. Blanche about his recusal, his supposed recusal. I asked him if he talked to Mr. Terrell. He acknowledged that he did. I asked him if he was advised by Mr. Terrell. Did Mr. Terrell tell you that ethics laws and policies required that you not be involved in cases involving your prior representation of the president? His answer was yes. So in those three matters, the hush money payment case, January 6th case, Mar-a-Lago case, you were to recuse yourself. His answer was, I'm recused, correct? Well, by the way, he said the cases are not ongoing, Senator. Yes. But to the extent there's any work around those cases, yes, I'm recused. So then I brought up, and you must have watched the hearing, so you said to CPAC a couple months ago, the other things that are happening, there was not a single man or woman at the Department of Justice who had anything to do with those prosecutions, meaning the prosecution of the president. Now, you had something to do with those prosecutions, right?
I was a spokesman for the office.
For the Office of the Special Counsel.
Correct.
That was leading both of those investigations into Mar-a-Lago, the classified documents and obstruction case, as well as the January 6th case.
Correct.
So by by what he described to CPAC, you were included among those not left standing as a result of those firings. So I asked him, so you're saying that it's not a conflict of interest for you to be involved in the firing of prosecutors who prosecuted your client, your former client. There's no conflict there. Is that and his answer was no, there is. They said there is a conflict of interest. I wasn't involved. That would be a conflict of interest. But he fired you, right?
He signed my termination notice, yes.
He signed your termination notice. So he signed the termination of someone who worked on the prosecution of his former client and arguably his current client, Donald Trump.
Correct.
I mean, it seems to me that was a pretty direct lie he told to our committee. Now, maybe he would quarrel with describing him as a prosecutor, but he wasn't quibbling over that when he was speaking to CPAC. He said no one involved in those cases is still remaining at the department. And when I asked him about taking credit for that, he said, no, that was just a statement I made. But wouldn't it also be a conflict of interest if that supposed tax agreement impacted Trump's potential liability for what had been mischaracterized as business payments? The hush money payments, according to the statement of facts in that indictment, were designed to conceal their true nature and in so doing mislead tax authorities. Wouldn't the signing of that settlement also impact his client potentially in that kind of a case?
I defer to the lawyers on the panel. I am not a lawyer. So.
Yeah.
Senator Schiff, I expect that the lack of transparency around Donald Trump's finances would, if reversed, reveal a lot of conflicts of interest. And I think you're absolutely right that the firing of U.S. attorneys or spokesmen, individuals who were involved in any way in those cases, was, as you seem to be suggesting, largely motivated by not wanting those individuals to be involved moving forward. I think a Department of Justice headed by Todd Blanche would have conflicts of interest and problems with regard to lawyers' ethics shot through it at every level, which is why my concern is that if recusal were done right in his case, he would be recusing from the vast majority of what the Department of Justice is currently doing.
I completely agree. Mr. Carr, if I could just return to you for a moment. He signed your termination. Are you aware of whether he signed any terminations involving any of the other members of Jack Smith's team?
I don't know. I did reach out to a few of them. Some of them were fired before he became a Deputy Attorney General. Others were fired after. So I don't know. I will say...
I would be very interested if any of your colleagues share with you. I think we would all be interested to know whether you're not the only one that he fired on the on the Smith team, or in any of the investigations that he is supposedly recused from. Mr. Carbone, I asked Mr. Blanche a question at the end of the hearing. It was kind of interesting because most of the fact-based questions I asked him, he dodged. The one more or less rhetorical question he really seemed determined to answer, which is what happened to you? What happened to the Todd Blanche of the Southern District of New York who was a respected prosecutor? You knew him, you worked with him. I understand from others in your old office that he was held in high regard. What do you think happened to him?
Well, Senator, you were in the room when I gave my opening remarks, but as I said, I worked closely with him. I personally liked him, I respected him, and I valued our relationship. He was a very affable prosecutor. He was fair-minded. He had a lot of good qualities. I don't know what happened to him. I do know what I see, and I can only judge his conduct. I have not had any extensive contact with him in the past year, 2 years. It's been very fleeting, and I don't know what happened, but he certainly is not the person that I once worked with.
Yeah, it's interesting, and I mentioned this at the hearing. I don't think people change that much. I suspect it's more that we don't really know who they are until they show themselves, until they are forced to make a difficult decision between their ambition and their principles. And we've seen this. He's not alone in this. We've seen this from so many people who work in this building or the administration who come to Congress or come to the administration as one person and seemingly transmogrified to something completely different. And I suspect that character flaw was there all along. They just never were forced to make the choices that reveal who they really are. The last question, Ms. Stein, and thank you so much for being here. I was struck by the completely anomalous behavior of Mr. Blanche going to interview one of the co-conspirators, the primary co-conspirator of Jeffrey Epstein, Maxwell. The fact that he seemed to take no one who really knew the facts of the case, which no self-respecting prosecutor would do, that he didn't challenge any of her many misrepresentations, and that magically she ended up in this prison camp afterwards, unsuited for a sex predator like her. How did victims feel watching that spectacle, that charade? What was that like?
Very difficult for us, as it would be very difficult for any victim of crime. Ghislaine Maxwell has shown herself to perjure herself in civil litigation, and it really wasn't lost on us that Mr. Blanche spent 9 hours, 2 days interviewing her, but for months and months and months, we couldn't get in front of the Department of Justice. And when we did, we had about an hour with Mr. Blanche, which was nothing in comparison. Maxwell's move to a low-security facility is unprecedented for anyone with a conviction that she holds. I mean, it's just unheard of. We are further concerned because this administration has not ruled out a pardon. This woman was convicted of sex trafficking, and she's been given preferential treatment over and over and over again, and that just begs us to ask, why?
Thank you. Thank you, Mr. Chairman, Senator Durbin, for your indulgence in allowing me to go ahead. Thank you, Mr. Chairman. Mr. Adler, thank you for being here and for your many years of service. Ms. Oyer, likewise, thank you for your courage at the Justice Department and for your willingness to speak out. Ms. Boss, I'm just heartbroken for your loss and very much appreciate your advocacy. And Ms. Bensky, thank you for your willingness to speak out and for all of the Epstein victims that are here. I'm glad the Attorney General finally acknowledged that he could meet with you. I was perplexed when he said somehow that he was prohibited. That's simply not the law, and I hope that meeting takes place. Mr. Ashcroft, thank you for your service. I wanted to ask you about some remarks the Attorney General made when he said that he thought the president, he was asked about the president targeting his political opponents and enemies for prosecution. And I don't subscribe to what I think is a false equivalence. We've never seen a president behave this way, where he openly and privately calls on the Attorney General to prosecute his enemies. And I want to ask you about that, Mr. Ashcroft, because Mr. Blanche has said that he believes the president has both the right and the duty to use the Justice Department to go after his enemies. Do you subscribe to that view?
Thank you, Senator. I believe that the Attorney General of the United States has the right and responsibility to enforce the law uniformly. And if the law has been broken by the president's enemies, he has a duty. They do not become exempt from following the law merely by their enmity to the President of the United States. As a matter of fact, the people who break the law are in enmity with the people of the United States whose expression of what is the law has been developed in this body and the Congress of the United States. So we used to call people who break the law public enemies.
Well, Mr. Turner,
and so my view is that whether a person has been a political supporter or not of the President of the United States is not the determining factor regarding prosecution. It's whether a person has violated the law, and in enforcing the law, the Attorney General is carrying out the will expressed in the Congress.
Mr. Attorney General, you realize, having sat here, my time is very limited. That really isn't my question. My question is, do you think it is appropriate for the President to call on the Attorney General to prosecute one of his enemies, and acting on that, request the President for the Attorney General to do so?
The President of the United States is the executive branch of the United States whose charge it is to enforce the laws of the United States.
So
when the President of the United States asks that the laws be enforced, I don't see that as consistent with his duties or responsibilities. If the laws were to be enforced differentially, and which one of the things that scares me about as many laws as we have, someone said in order to run a police state, you only have to have one policeman. But if you have enough laws, you can go find something wrong with anybody you want.
Mr. Ashcroft,
so the President, I believe, his job is to have an administration which calls for the enforcement of the laws of the United States without regard to the political preferences of the people who are perpetrators or accused individuals in the system.
I'm not sure that I understand your answer, except you seem to accept the premise that it is okay now for a president to call the Attorney General and ask him to prosecute his enemies. You don't seem to have a problem with that. If you do have a problem with that, please say so.
I believe the President needs to be an advocate of strong law enforcement.
Okay, that
includes enemies of his.
With respect, Mr. Attorney General.
If an enemy of the President goes out and conducts a violent crime, it's nothing wrong with the President calling the Attorney General and saying, I hope you do something about this violent crime.
And if the President's enemy takes a photo of seashells, you think it's appropriate to prosecute them? If senators make a video stating the plain law and Constitution that you can disobey an illegal order, you think it's okay for the President or others to call on them to be prosecuted? I don't think so. I don't think so. And I don't think you would have done that as Attorney General. I hope you wouldn't have. If you would have, you were not the Attorney General I thought you were. I don't think it's appropriate for this Attorney General or any other. And I don't remember seeing, notwithstanding the false equivalence I hear expressed so many times from my colleagues in this committee, I don't remember any Democratic president calling the Attorney General and saying, you need to prosecute him, and you need to prosecute her, and you need to prosecute them, and you need to go after this organization. We have never seen that before or anything like it. Anything like it. And generic statements, oh, they all do it, is simply not the case. And by making that argument, it just further erodes the wall of independence that I'm sure, Attorney General, you remember after Watergate, when because of the abuses of President Nixon, there was an effort to make the Justice Department independent from the White House, not completely independent in the sense that the president couldn't set general priorities. I want you to emphasize these cases and these cases, whether it's immigration cases or drug cases. That was always appropriate. But what has never been appropriate, and particularly so after Watergate, was for the Attorney General of the United States to break that wall and call on his Attorney General to prosecute his enemies. And I would say even without any basis to do so. And this Justice Department has been willing to do so and has gone before grand juries, and we have never, I think, seen the likes of this either in these high-profile cases where the grand jurors, in some cases to a person, have refused an indictment. How often did you have that happen to you, Mr. Attorney? Last question I'll ask you. How often, Mr. Attorney General, did you seek an indictment as a prosecutor and have not a single grand juror vote to indict? Did that ever happen to you?
I don't know. I just don't know.
I thank you, Mr. Chairman.
Senator Brett.
Thank you. My questions are going to be for Mr. Carbone. I spent 4 years as the United States Attorney in Rhode Island and 4 years as our Attorney General. As you may know, Rhode Island is one of the 3 states in the country where the Attorney General has full criminal authority. We don't have DAs. It's us, Delaware, and Alaska. And so we worked very closely with my successor as U.S. Attorney once I was elected. So I've got some experience and understanding of the traditions and protocols and standards of the department. So I say that by way of opening. I have a word cloud here of things that sitting federal judges have said about the Department of Justice's presentations in this Trump II administration. To be clear, these are not allegations that are made about the Department of Justice by angry or frustrated opponents. These are findings made by federal judges. And I think every one of those words, if it had been spoken about my office when I was U.S. Attorney, would have occasioned an office response. We would at minimum have had a meeting with the attorney and asked for an explanation. It could very well have resulted in a referral to OPR, Office of Professional Responsibility, within the Department of Justice, which, by the way, I'd need to see a proof of life from right now. And it could easily have meant like going over to the court to try to make amends and set things right, because the department's reputation with courts is its most important asset. What was the case in all your years in the so-called Sovereign District of New York with respect to that type of adverse finding about the competence and honesty of AUSAs?
You know, Senator, that's a really good point. You know, we talk about the Justice Department losing credibility and losing the trust of the public. And we don't talk enough about what happens when you lose the trust of the bench. We have a acting attorney general who has referred to the bench as declaring war on the activist judges. I can tell you this, in my years in running White Plains in particular, as well as downtown in Manhattan, if a judge had a problem with an assistant United States attorney, and it could be what now I would see as a very minor problem, I would immediately deal with it and speak to the assistant, figure out what happened, listen to the judge's complaints carefully. But if a judge made a finding that someone was less than candid or failed to comply with an order, that's really a big deal. And when a judge makes a finding like that, under traditional, as you know, from being a U.S. attorney, that's something that would be reported to Maine Justice, and it would be something that would be carefully evaluated. If there's a Brady violation, carefully evaluated. What I think we see now is a broad lack of trust by the bench in the representations that are made by the government. There was a time when an assistant United States attorney walked into a courtroom and said, "I represent the government." That meant something. It meant something because the judges were confident that that assistant United States attorney was going to be candid, was going to be well prepared, and was going to be doing the right thing. And I think, sadly, what that collage reflects is a sentiment from many judges that's no longer the case.
For the record, that included Trump-appointed judges saying those things about lawyers. This is not just so-called activist judges. The department almost makes it worse when they receive criticism, and instead of responding to it honorably, they turn on and attack the judges. Well, the judges tend to know each other. And when a judge who every other judge knows and knows perfectly well is no activist gets called an activist, that's just further damage to the department's credibility. Say a word about
and ability to actually do the mission of the Justice Department, to carry out justice. When you don't have credibility with the court, or you lose credibility with the court more broadly.
Say a word about the presumption of regularity. What is that phrase? What does it mean? What does it matter for the department?
Well, the presumption of regularity is something that the department has enjoyed, at least in my years in the department. The judges assume that you're acting in good faith and that nothing improper happened or untoward. In the context of getting grand jury minutes or getting access to grand jury minutes, we've seen unprecedented number of judges ordering access to the grand jury minutes. That, as you know, that's something that the law is very, it's very, very good for the government on. You don't get access to grand jury minutes unless you can show there's a reason to go behind, because there is a presumption of regularity. Well, that presumption more and more is no longer attaching.
If you don't mind, one last episode that I'll walk you through. This was an episode not in the Southern District of New York, but here in the District of Columbia, by a political appointee directly supervised by Todd Blanche. And it was basically a cooked-up criminal investigation. First of all, it was a criminal investigation that was pursued without predication that there was a crime. Would that be unusual in a normal Department of Justice?
Well, certainly when it comes to the more complicated the case, the more sensitive the case, the more predication you should have before beginning an investigation.
But there should, at a minimum, be some
There should
predication.
be, even in the simplest of cases, there should be some predication.
And when the criminal chief of the career criminal chief of the office loses her job for being unwilling to pursue the no predication criminal investigation, that in a normal Department of Justice would be another warning sign, would it not?
It would be a red flashing light.
Yeah. And if no career member of the office would be willing to sign a pleading and the U.S. attorney went forward alone with zero willingness to co-sign the pleading by any career person, another red flag?
Flashing lights.
Yeah, flashing lights. And if the U.S. attorney went forward themselves with no career co-signer and had zero federal prosecution experience at the time. That would be more red flags, wouldn't it?
That would be a very, very serious problem.
Yeah, going into the magistrate's office, the rest of the courthouse would have heard about that by sundown. And the magistrate judge then denied that acting U.S. attorney's petition. That's a pretty damned rare occurrence because department lawyers bend over backwards to make sure that they don't put judges in the position of having to deny petitions by super preparing to make sure that there is no occasion for a judge to deny the warrant application.
Well said. And I just want to point out, in that scenario, kudos to those career public servants who refused to sign off
Yeah.
on that.
And then after the magistrate denied